kinetic conflicts,
brutal ethnically based attacks,
humanitarian crises,
the escalation of the trade war,
broken partnerships and economic uncertainty, disinformation,
vaccine mandates that are damaging, injuring people and killing people,
social disruption, cyber attacks. In an interconnected but increasingly chaotic world, identifying what constitutes a breach of international law is paramount, especially when such a breach extends to the cyber context, rendering all states vulnerable. So, it can be helpful for a country to establish a clear national position on cyberspace to prepare for and even deter new threats coming from cyberspace.
The Czech Republic recognizes that international humanitarian law applies to cyber operation during armed conflict.
States should be guided by restraint and avoid an arms race in cyberspace.
Drafting a new legal position in response to new and emerging challenges isn't necessarily straightforward. That's why a consortium of stakeholders and partners have produced the Handbook on Developing a National Position on International Law and Cyber Activities. Launched at SciCon 2025 in Tallinn, Estonia, this handbook offers practical guidance on how to develop national or common positions on international law as it applies in cyberspace. Authored with input from lawyers and diplomats, the handbook will serve as a critical resource for states worldwide, providing national governments with clear, elegant solutions to potentially complex problems. But why would states want to develop a national position on cyberspace? And what exactly is a national position to begin with?
So a national position on international law application in the cyber context is an official statement in which a state outlines their views on how international law applies to cyber activities. So it can contain questions like how do rules of sovereignty or non-intervention or the prohibition on the use of force apply to cyber activities? In other words, what is prohibited and what is permitted for states to do in the cyber context.
In that position statement, the government sets out its views on how international law applies in cyberspace. Until about 15 years ago, there were debates about whether international law applied at all, and if so, certainly how it applied, partly because the nature of cyberspace is of course boundaryless. There are no borders, whereas the international law system is traditionally based on territorial boundaries. So this has been something that states have really had to work out between themselves and come up with their own positions.
By drafting a legal position on cyberspace, a state can make clear its own operational standards and its expectations or red lines from other states, both allied and non-allied alike. So just what form can those red lines or threats in cyberspace take?
One way to answer that question is just to identify possible violations of established rules of international law. So you can imagine disinformation campaigns or the use of social media to sow discord and discontent within societies. Think of espionage. There's a debate as to whether espionage is unlawful under international law and whether exfiltration of data from government networks constitutes a violation of the territorial sovereignty of a state.
We might think of a state that launches a cyber attack on a power station in another country, perhaps as part of an armed conflict. There have been ransomware attacks on hospitals, also on transport systems, and those are sometimes carried out by malicious state actors like governments. Sometimes they're carried out by criminal gangs, and sometimes, unfortunately, increasingly, a combination of the two.
We've established what a national position on cyberspace is and what a cyber threat might be. With those in mind, what would be a trigger or the motivations for a state to draft a national position?
Typically, it is about reducing the risk of escalation, clarifying international law, not only talking to external audiences, but also internally and domestically.
My role as a military legal advisor is to protect fighting power by providing advice. So there's a military, tactical or strategic advantage to knowing what the law is. If you develop something that in the end, and that may take months or even years, that in the end turns out to be violating the law, you're hurting your own fighting power.
The publication of national legislation contributes to strengthen our efforts to deter malicious cyber operations by indicating the thresholds for the violations of various international obligations on one hand, and by also indicating that the recourses or responses we can make to such a malicious act in accordance with international law.
There's a need for the handbook regardless of how one assesses the current state of the world. The debate has the potential to recode the content of international law.
If we don't have any rules, then we're living in a lawless world. So it's really important for the rule of law that we have clarity about the law applying in this area, that it can apply.
What happens in cyberspace from a legal perspective will not stay in cyberspace. So in short, the debate is too important. The stakes are too high, and the handbook is a great tool for government lawyers and policymakers who want to think about these questions and think about how to develop their own national views on it.
So, if a state does decide to formulate its own national position on cyberspace, just what is the process for that? Watch the next film to find out.